En na mana, en na reo, en na iwi, e ro ranga tirama, tena koto katawa, na mai hare mai. Kwikwi mai tato katawa, kiora, ko Dalin toko ingawa. Welcome. My name is Dalin, and I'm a senior lecturer here on this law faculty, and I have the honor of being on the organizing committee for this year's Sir Ivor Richardson Lecture in Private Law, together with Justice Koch, Justice Palmer, and Professor Graham Alston. This is the third lecture in the Sir Ivor Lecture in Private Law series, and this lecture series is named, as many of you know, for a legal giant. Sir Ivor held multiple careers in law, in government, in academics, in private practice, and in the judiciary, and he made enduring contributions in each role. He was a professor here on Victoria's Law faculty, where he revamped the curriculum in taxation and other commercial law subjects before serving as dean of the law faculty and subsequently chancellor of the whole university. When Sir Ivor left teaching, he went into private practice before being appointed to the High Court, and just mere month after, to the Court of Appeals. He served on the Court of Appeals for 25 years, including as the court's president for the last 6 years of his service. After his retirement, Sir Ivor returned to our law faculty as a distinguished fellow. He received honorary doctorates in law from both Victoria University and Canterbury University, and he was appointed principal companion of the New Zealand Order of Merit. Many of you knew Sir Ivor personally, and even in the short time since I've joined the university, I've heard countless stories about his sterling intellect, about his commitment to service, and about his legacy of mentorship, of helping launch the careers and lives of countless lawyers, judges, academics, and public servants. I'm told that he regularly came into the law school and was an unswerving supporter of the work of the legal academics who now occupy the building next door. Now, I'm absolutely delighted to have the privilege of introducing our speaker for this evening, Professor Mindy Chen-Wishart, who not only exemplifies Sir Ivor's blazing intellect, but also his unfailing commitment to service, of working for the benefit of community. Before I turn to that introduction, however, I just want to outline the format for this evening. I will provide an introduction. Mindy will speak for around 45 minutes. We will take a few questions, and Justice Koch will give a vote of thanks. I also want to express our gratitude to some others whose contributions made this event possible. So specifically, I want to thank Minter Ellison Watts for their generous financial support for this lecture. The firm, the predecessor of which was Sir Ivor's firm when he was in private practice, has supported this lecture series for multiple years now, so thank you. I also want to thank the law faculty for its support of this lecture, and particularly, I want to acknowledge the professional staff, both at the law school and at the Central University, who worked tirelessly behind the scenes to make everything happen tonight. And finally, I want to welcome Mindy's sisters, Annie and May, who are here with us today. So, given the time I've been allotted, I simply cannot provide you with a full outline of Mindy's towering achievements and contributions to law to date. So I will attempt a very brief sketch instead. Mindy is the Provost Chair Professor at the National University of Singapore, an Emeritus Professor at Oxford University, and an Emeritus Fellow in Law at Oxford's Merton College. She was also Dean of the Faculty of Law of Oxford from 2020 to 2023. She is the author of seminal scholarly works in contract theory, contract jurisprudence, and comparative law, in addition to her own textbook on contracts and serving as an editor of the classic contract treatise, Chitty on Contracts, Mindy is currently leading a series of books to provide an authoritative account of the contract law regimes of select Asian jurisdictions, turning a spotlight on major centers of commerce that have thus far received sparse attention from commentaries provided in the English language. She is also an honorary professor at the University of Tago, where she was awarded an honorary doctorate in 2023. In 2024, Mindy received the Lifetime Achievement Award at KCON, which is the leading international contracts and commercial law conference. Now, Mindy's reputation for excellence precedes her, not only as a scholar, but as a teacher as well. I recently learned that when she taught at Oxford, she held what are called walking tutorials, where she will walk through the meadows of Oxfordshire, answering students' questions about concepts and cases. And the idea was that this not only injected some fun into what could seem somewhat intimidating, the intimidating reputation of office hours, something that us academics should really consider, but it also fueled students to take charge of their own learning. Finally, I want to add one thing about Mindy from my personal perspective as an Asian legal scholar, particularly because I see some current and recently graduated members of Victoria's Asian Law Students Association here in this room. When I decided to go to law school, I did not know a single real lawyer. And in my first year, I felt like I was being taught a secret language, one that many of my classmates, in fact, already knew. When it came time to apply for summer clerkships, I was clueless about how to craft a successful legal application, let alone envision a successful legal career. There were not many Asian lawyers in high-profile positions at the time, and even fewer Asian women. I couldn't find a role model who looked like me doing the type of work I was interested in. And a lot has changed, of course, since then, but I think my experience still resonates with some Asian law students today. And there is still a strong temptation among young Asian lawyers, most of whom are first-generation lawyers, to shy away from Asian-oriented legal practices or topics and just emulate how Pekka lawyers develop their careers, to separate just as much as possible who you are from what you do. Mindy breaks this mold, and she has shown us both the importance of fusing our personal communities and cultural roots with our work, and also how to do it well. How to be a path-breaking scholar who has led one of the top legal faculties in the world, and who writes, thinks, and studies Eastern as well as Western legal traditions with rigor and imagination. So please join me in welcoming Professor Mindy Chen-Wishart to deliver the 2026 Sir Ivor Richardson Lecture in Private Law.
Can you hear me? Is that okay? Great. Okay, well, thank you so much, Dart. In the late 1980s and early 90s, I was just far too lowly an academic in Otago to have even touched the hem of Sir Ivor Richardson's gown. But I see from his biography that we were both South Islanders, hooray. We were both studying Latin, being interested in history, being academics, being dean, but beyond that, Sir Ivor leaves me in the dust. His CV is clearly breathtakingly glittering. He's an adventurous soul. He was willing to take on lots of different things, and in all of them, he rose to the highest level at lightning speed. And he made clearly long-lasting contributions to New Zealand law and education. I really wish I had interacted with him, as my sister May has. I love her accounts of how wonderful he was and how he delivered his advice with a devastating question, which is what I aspire to. So it's my huge honour to deliver this lecture. Thank you for asking me. I never forget that New Zealand made me, New Zealand educated me, and if there's an opportunity to do something for New Zealand, I'm there, I'm eager. In fact, this is the first occasion where Victoria's asked me to do anything. And when they said that they... oh, that wasn't actually meant for laughs. but you know, when the committee said, you know, wait, we still need to raise the funds, I said, no problem, I'll pay. I'm coming, you know. So, okay, here we go. In the animal kingdom, Homo sapiens are weak. We are furless, fangless, and clawless. Newly hatched turtles can shuffle to the ocean. Newborn giraffes can walk after 10 minutes. They can run at full speed in 10 hours, and they can leave their mothers at 18 months. But modern humans, we're just blobs, right? It takes us 18 years, and usually much, much longer, to become independent, says the bitter mother of 3 grown men, right? Right. And yet, we are the most dominant and lethal species on Earth, right? 96% of mammals on Earth today are us or animals we've domesticated. Other species like bees and wolves, they can cooperate, and based on kinship ties, but humans have an unparalleled ability to cooperate and coordinate with strangers through a shared fiction that really exists solely in our imagination. Money, law, and nations are all powerful fictions, and they enable large-scale human cooperation. But perhaps, I would say that, wouldn't I? The most transformative of these is the contract. We make contracts to enhance our welfare. If we need or want something, we can make it if we can. We can take it by force, which is kind of risky, or we can trade for it. Trading is the essence of contracting. Both parties get something they value more than the thing they gave up. Trading lets us specialize. We don't have to be self-sufficient. A lawyer can focus on lawyering because chains of agreement connect her to everything she needs. Food, clothing, shelter, leisure, dating apps, coffee, more coffee. Modern life is sustained by contracts all the way down, with each link in these networks supported by dozens more, right? Which one is that, anyway? Okay, so we can't survive without making contracts, but we take it completely for granted. Making contracts also, making contracts also expands our freedom. In liberal democratic societies like New Zealand, we celebrate the freedom to live our lives, right? Our jobs, leisure, homes, holidays, questionable fashion sense, purple hair. The main mechanism for all of these is by making contracts. So Henry Maine described the evolution of progressive societies as one from status to contract. Now, contract law arose because of a particular problem. Within our intimate circles, close friends, close friends, family, colleagues, trust comes naturally. Our interests are interconnected, we know each other's reliability, and we can apply social pressure. We can tell everyone what a loser they are. We can not do them any favours, we can freeze them out. But how do we widen our choices with strangers? With someone from another city, another country, another continent, whom we might never meet or might never see again. How do we trust strangers? Enter contract law, humanity's most successful tool for synthetic trust. It lets a startup in Sydney hire programmers in Bangalore, and they're confident that the work will be done and payment made. It lets us project our intentions into the future and plan actions that need concrete pre-commitments. But for the support of the law, contracts between strangers would not be as common as they are. Like participants in a hostage swap, we'd regard each other with great suspicion, and we'd say, you go first, all right? Contract lets us transcend the them and us, turning strangers into potential partners. Otherwise, we'd only deal with those with great reputations for trustworthiness, or we'd have to rely on non-legal methods of enforcement. Think about the mafia and the horse's head in your bed, right? A contract is an abstract concept. It's constructed and identifiable only via contract law. In recognising and enforcing contracts, the state is subsidising our exchanges. But this subsidy doesn't have to be given absolutely or always. Contract law must lay down the rules of the contract game. What is it? How do we play it? What can we get from it? And what happens when things don't go to plan? At its very basic, a contract is an agreed exchange that the parties intend to be binding. And this generates three irreducible minimums of a contract and therefore of contract law. First is voluntariness. Contract law must identify the parties' intentions and find a consensus, respond to problems in negotiations, and deal with the unexpected and the unforeseen that by definition they could not have agreed to. The second is reciprocity. Contract law must ensure that there was an exchange, determine its precise content, and deal with unfairness and illegality in the contents. Now, critics often point to civil law jurisdictions like Germany and China, and they say, hey, they don't seem to require consideration and exchange, but the devil's in the detail, and the detail shrinks the difference hugely. Civil law is broadly the mirror image of the common law. So common law says we enforce exchanges unless you've got the necessary formalities. And civil law says we require formalities unless it's an exchange. It's not that different. Okay, and civil law doesn't treat gratuitous promises like exchanges. In some jurisdictions, gratuitous promises are revocable before performance, and that means they are not enforceable contracts. And gratuitous promises can be struck down for more reasons than exchanges. For example, a material deterioration of the donor's economic circumstance, or the donee's ingratitude. I'm thinking of my 3 sons again, right? Now, the third irreducible element of contract law is, of course, to determine the proper remedies for breach of contract. Now, contract law rules on voluntariness, reciprocity, and redress are constitutive of an enforceable contract. They define what a contract is. They don't depend on the parties' agreement, and they can't be contracted out of. Otherwise, it would allow contract to cannibalize itself via contract. If you change the rules of chess, you are no longer playing chess. So you can't agree that you don't need an exchange for an informal contract. You can't agree that fraud and duress are okay. You are severely restricted on ousting default rules on remedies. For example, you can't agree that you will have specific performance. You can't allow remedies, you can't allow penalties. But what's the size and shape of each of these, right? What's a voluntary agreement? What kind of exchanges are allowed? And what's the appropriate remedies? Well, at common law, of course, the answer is always, it depends. And this drives the students crazy, right? And here I want to detour to the nature of common law reasoning. This is a project that is not finished. I'm working on with Professor Shiv Swaminathan. And common lawyers are often seen as inferior to the apparently more cerebral academic philosophers, scientists, mathematicians, and economists. A running joke is that there's no Nobel Prize in law because common lawyers are fundamentally incapable of original thought. And at least the civil lawyer is committed to the law as science paradigm, right? And I always remember and tell my students that Patrick Attia famously said, you can defeat any brilliant legal argument by saying, ha, but no one's thought of it before. So common lawyers seem to muddle through from case to case. In fact, we've yet to settle on a reliable formula for determining the ratio of a case. Max Weber talked about irrationality, and others refer to the judge's breakfast. Now, when I taught English law to Chinese judges, they complained bitterly that no one knows for sure what the law is. So that, they alleged, compared to China, England has no rule of law. Okay. But the common lawyer, but I would suggest that the common lawyer's seemingly inelegant, muddling ways are in fact the essence of an ingenious, wise, and ancient method of doing practical philosophy, geared to cutting through difficult and perennial moral problems. Faced with a problem, 8 out of 10 common lawyers can converge on a solution in the time it would take an academic philosopher to clear their throat before embarking on a prolonged, likely intractable debate over abstractions. The complexity involved in detecting the ratio of a case is itself the result of the common law's sophisticated philosophical outlook. Now, I'm going to start with the orthodox story of the doctrine of precedent. So the idea, the story that we were all told from year one, judges solve each problem as it comes up. They build up a collection of thousands of responses to conflicts, and when a new situation arises, judges search through this vast collection and they reason by analogy, either extending a past case because of similarity or refusing to because of a dissimilarity. But I have questions, First, how were the cases decided in the first place? It's the same argument. If God made everything, who made God, right? How did they come up with the first cases? And can past precedents really inform really novel situations? For example, AI contracting, catastrophic mistakes that happen from there. When AI contracting doesn't involve human consciousness in any realistic sense. And how do judges decide when a case is similar to or different from previous cases? Any two cases share some similarities and will have some differences. It all depends on how specifically you state the ratio of the precedent, all right? So Donahue and Stevenson, is it about a defective product, or is it about a snail? You've got to have a snail before you can, so it all depends. So theoretically, it's always possible for a judge to find that a convenient precedent applies and an inconvenient one doesn't. And how do we explain the malleability of reasoning that allows a judge to find a completely new ratio, sometimes 50, 100 years after it was first decided? Now, these seeming bugs actually reflect crucial features of the common law method. Contrary to orthodoxy, we argue that the arrow of legal reasoning doesn't move from past cases to the present case. Instead, it moves in the reverse direction, from present case to the past case. And I'm going to be brave enough to say, even if judges don't admit it. All right? Judges decide what seems fair and just in a specific situation, and then they think, well, what is acceptable? And then explain their decision by pointing to how they handled something previously. And this brings to mind 2 private conversations I've had with some law lords. Okay, here they are. Okay. I think Hoffman looks particularly shifty there. Okay, so I asked Lord Gough this is how old I am, White and Jones, and it was a landmark, and we were having dinner, and I asked him about it soon after it was decided. And he said, well, Lindy, we all knew what the right answer was. The question was, how were we going to get there, right? And I remember asking Lord Hoffman about how he reached the decision to separate the conjoined twins, Mary and Jodie, when separation meant that the weaker twin would inevitably die. But left as they were, as the religious parents wanted, both were likely to die. And he said to me, well, it was obviously the right thing to do. I was ready for a detailed, exegesis. So I had two reactions to what he said. I thought, if a law student said that to me, they would get a really low mark. And my second thought was, that's just what my husband said. Perhaps I shouldn't have been quite so dismissive, I was like, you don't understand, So more specifically, right, number one, the judges anticipate what's likely to pass muster with the legal community, comprising of other judges, members of the bar, and perhaps maybe a very few legal academics. Second, this is based on tacit knowledge, an aesthetic sense or skill picked up osmotically from doing, right? From being steeped in the legal community for a length of time, having internalized its gaze, and having seen enough cases being decided. This is fundamentally the way common law appoints its judges. The knowledge needed to make all decisions is regarded as spread across many different judges. So drawing on Michael Polanyi's polycentrism, the idea is of decentralized decision-making, but through ongoing real-time coordination between many decision-makers, past, present, and future, who adapt to one another as the situations unfold. So judges look to past decisions. Why? Not to make the decision, but to explain the decision. The goal is to persuade others by appealing to solutions that the community has already accepted before. When analogizing, the ratio of the past case invoked is framed in a way that highlights a similarity with the present case. When distinguishing, the past case is constricted so that it does not subsume the present case. There's no rational blueprint to guide them. Over time, through handling cases one by one, the legal community develops a shared sense of what's acceptable. But judges can always adjust their approaches if circumstances seem different or if past responses now seem unreasonable. And it's all of this that lends the common law its extraordinary malleability, making it like the river of Heraclitus, ancient but constantly renewed without loss of identity. It explains why a judge deciding a case plays such a crucial role when it comes to formulating the ratio of a past case. It explains how normative constraints are possible at all in analogical reasoning. It makes sense of much of the common law that's otherwise likely to come across to the uninitiated as gobbledygook. Concepts like negligence, reasonableness, fundamental, foreseeable. After all, I'd say to my students, everything is foreseeable if you're paranoid enough, right? So it also makes sense of Sir Edward Cook's idea of artificial reason. The law is not accessible through mere intelligence or logic alone, but requires apprenticeship, years of immersion in the legal tradition, precedent, and custom. After all, like surgery, I wouldn't want a surgeon who just read textbooks and thought about it, right? It also makes sense of Hume's account of justice, which refers to expectations of what will pass muster with the community, causing the agent to correct or adjust their own view. Closer to our own times, Oliver Wendell Holmes Jr. says, the life of the law is not logic but experience, where experience requires insight, tacit and specific knowledge. Brian Simpson also talks about common law not as a body of rules, but as a practice that's received by the community of legal professionals. We must never lose sight of the fact that the primary purpose of all law is to solve human problems. So the law must take account of human concerns, human aspirations, behaviours, communities, institutions, and limitations. Indeed, the common law works along shared understandings of common ways and practices, because this will have better traction with the community of judges, with the community. Judges' reasonings are constrained by what's likely to be accepted by the community. Now, all of this contrasts with the academically dominant rationalist theories generated by armchair theorists, armchair philosophers. You can see how much I love them. They expound foundational norms, values, and standards that judges should conform to, and therefore can be said to have got right or wrong. The idea is we can deduce an entire area of law based on one or more master principles, whether it's utilitarianism or deontological ones like promise or rights or will or consent. And they also presuppose that one mind, one judge, can capture the whole lot. Now, these theories are attractive because they seem clear and logical. They're internally consistent. They're philosophically elegant. And coming up with one helps with your tenure or your promotion. But they're unrealistic. They are bloodless abstractions, right? They take an unrealistic view of the human being, the human subject. For example, as fictional, informed, rational wealth maximizers, or as the atomistic, detached right holder. Now, in fact, we humans are a bit of a mess. You know, we're social, we're emotional, we're often rational, irrational, we have limited processing power, we operate with partial information, and we change our minds over time. Rationalist theories also assume that the courts have perfect information, reasoning, enforcement, when in fact they've got limited time, information, and ability to design perfect solutions. Most theories claim to be universal. Most of these, monistic theories, but they're built around liberal Western values of the rugged individual, when many other societies are far more communitarian. Pluralistic theories are typically deployed as criticisms of monistic theories, but they never land because they don't say how we're supposed to rank or balance the competing values. Now, the biggest problem is that they don't fit the law they're supposed to be theorizing about. Their standard responses are, well, we're going to redefine our terms, right? Like Cinderella's sisters, they will make that shoe fit, all right? Or here is a less Disney, more grisly version, right? Or these rational theorists, they help themselves to other values, but they never explain why and when they're about to do it. Or they say that the cases have got it wrong, right? But my view is, if so many judges are getting it wrong, maybe their theory is the problem, not the judges. Now, Jane Stapleton, one of my favourite people, in her Clarendon lecture called Taking Judges Seriously versus Grand Theories, she said, truth-based theorizing has made academics and common law practitioners ships that pass in the night, all right? And I often think that with my colleagues. I just think, this is only going on in your head. Do you know that? You know, it has nothing to do with what's actually happening. So a true collaboration is only possible if academics take what judges do seriously, and that means taking the cases seriously. And I remember discussing this with an Oxford theorist who looked at me aghast, horrified. He said, oh, but that would mean I'd have to read all the cases, you know? And it's no accident that his students called him the case-free zone. right? And when I taught philosophical foundations of the common law, a co-teacher would often look daggers at me and say, "Oh, Mindy, you always know a case, don't you?" You know, it was clearly not a compliment. But I think that from the messy case law, we can glean factors that have resonated with the courts that pull at judicial intuitions, the trained intuition, and they may or may not be expressly spelt out, but I think seasoned lawyers can read them back from the cases and rely on them to anticipate judicial behaviour and advise clients. Now, recall the irreducible minimums of voluntariness, reciprocity, and remedies. This comes from my very short introduction. That's why there's chapters in it. My thesis is that in determining the size and shape of these three central features, 5 factors have resonated with the courts. Freedom, fairness, community, efficiency, and administrability. In the diagram, each side represents one of these values. Each value covers a range of concerns. The arrows show how these factors push and pull against one another, creating dynamic tensions that ultimately shape the contours of case law on any given issue, in any given context, culture, and time. Now, the diagram gives a rough and ready depiction of the terrain. It's like the depiction of France as a hexagon in school geography lessons. It's no help navigating according to this, right? Navigationally, this is useless. But likewise, the 5 factors are very useful as mental shortcuts, right? Or pedagogical devices. But they're not, and nor are they meant to be, treated by judges or lawyers as pre-specified criteria to be mechanically balanced based on a case-by-case basis. Actual decisions are always the product of what's fair and just that will pass muster with the legal community based on tacit knowledge. Reassuringly, I think all 5 factors are legitimate concerns of the state, and I've only got time to give a very brief description. Unsurprisingly, the foremost factor is freedom. Even illiberal societies that allow contracting care about freedom. Even North Korea will allow its citizens to have one of these 28 approved hairstyles. That's what you can choose from. The conventional understanding of freedom is freedom from restraint, negative freedom. We should be able to do whatever we want, the law shouldn't interfere. And this reminds me of my eldest son turning 16 and saying, "I'm 16 now, you can't tell me what to do." And my reply was, "You're 16 now, I no longer have to keep you." So this is, I found, quite good mutual nuclear deterrence. So if negative freedom was indeed the only concern of contract law, as the will theorists or the promise theorists claim, then I always say the study of contract law would take an hour at the most. It would not require, you just have to find the parties' intentions and apply it, right? It wouldn't need the thousands of pages of Chitty or Williston on contracts to expound. Now, in truth, the study of contract law is the study of the limits of freedom of contract. Freedom means that there must be voluntary intention to make contracts, but due to fairness, efficiency, administrability, and social expectations, common law doesn't look for your actual intention, right? They settle for your objective intention. But then fairness and freedom means that there's limited relief for mistake, and that itself cuts back on efficiency and administrability. So the empire strikes back. Now, freedom seems to dictate that the contents of a contract is what the parties agreed. But we see that courts are very concerned with fairness in the way they interpret contracts, contra profferentum, they add to contracts, terms, collateral terms, implied terms, they subtract unfair terms, right? These are usually justified by the presumed will of the parties. But the parties are irrebuttably presumed to be reasonable. And judges will speak for the reasonable man, right? It wouldn't matter if I brought along 10 character witnesses to say, Mindy is a bitch. She's completely unreasonable and she would not have intended to act reasonably, right? I don't think that I would get anywhere, right? So freedom would require, of course, the enforcement of the contract. And when I buy a pizza, I want the pizza. I don't want damages for not getting a pizza, right? But that's all I'll get, if anything, after mitigation. And let's think about the many bars to specific performance. What do they show? They show a concern with fairness, hardship, inadequacy of consideration, lack of clean hands. These are all reasons you're not going to get specific performance. They're worried about efficiency. Think about the bar of waste. They're worried about administrability. Think about the bar of impossibility, uncertainty, constant supervision. Freedom makes another appearance. So there's a bar of contracted personal services, and of course, you can happily change your mind if damages would be an adequate remedy. Okay, so contract law also, there's a perennial tension between freedom and fairness, right, which is key ideas in moral political philosophy that's fundamental to the legitimate goals of government. Broadly, this means respectful dealing that takes account of the other party's legitimate interests in the exercise of their freedom and in the avoidance of harsh outcomes that unduly threaten their welfare. But there's pushback due to freedom, administrability, efficiency, so there's no need for adequacy of consideration. But then we push back again. Vitiating factors can always strike down unfair terms. Right? Third factor, community. This is the context in which we become human. Our well-being depends largely on success in socially defined pursuits that are widely practiced in our society and that give them meaning. So contracts are embedded in social practices and shared norms. For example, contract law presumes that you don't intend to sue your family or friends who failed to pick you up or, didn't have their wallet with them and couldn't pay for dinner, right? They don't assume. So there's a presumption that these sort of contracts or these agreements are not intended to be sued upon, right? But freedom and efficiency pushes back and it allows a presumption to be rebutted. It can also be easy to exploit unsuspecting friends and family, so we have a doctrine of undue influence. Now, community values also means, for example, we don't allow baby selling contracts, right? Because it would debase our conception of human worth. Think about differential pricing, the premium baby and the discount baby, right? Right. And contract law interprets contractual standards through the social lens. Things like transaction calling for an explanation, unconscionability, right? Like I always say to the students, if you don't like something, you say it's an unconscionable bargain. But if you're not going to help them, you say it was a foolish bargain, right? So, number 4, law and economics scholars argue that efficiency is or should be the basis for contract law. But welfare maximization is hardly ever the sole reason that humans enter into contracts, unless you're a company. Economic analyses are frequently very rough guesstimates, and different models often produce very different answers. But still, the state has an interest in promoting productive economic activity and avoiding waste. So we have the duty to mitigate. You can terminate a breach against a hopeless contractor to salvage the original project. But concern with fairness limits the scope of both. And finally, administrability. Courts are not omniscient. They're generalists, resource-constrained, and dependent on evidence and procedure. So, difficulties of proof explain the signature rule, the parole evidence rule, but they're subject to loads of exceptions because we care about freedom, we care about fairness. We also see presumptions being used to overcome problems in proof. We see that in undue influence. The potential to be swamped by too many claims explains the reluctance to give damages for pain and suffering. So, obviously, if someone asks you, how upset were you? Oh, very upset, very, very upset, and you need to give me more. But likewise, freedom, fairness, and community necessitates exceptions. So, what's the relationship between the 5 factors. I'm almost there. Each of the factors is internally expansionary. Its logic is always to have more of itself, right? No factor contains within itself a principled stopping point, hence the implausibility of monistic theories. When pursued to its logical extreme, each factor leads to absurdity. For example, freedom without fairness risks exploitation enforced by the state. Fairness without administrability becomes moralized unpredictability. Efficiency without freedom is technocratic coercion. Community without freedom gives you excessive paternalism by the state. Administrability without fairness is just hollow formalism. None of the values are ultimate or teleological values. There's no predetermined ranking, weighting, or balancing. Ultimately, the weight of each factor depends on judges' overall assessment of what is fair and just, what will pass muster with the legal community, based on their years of gaining tacit knowledge and adjusted between past and present and future judges. Their answers will vary, right, over time, from community to community, whether you're capitalist or socialist, Judeo-Christian or Confucian, and they depend on the nature of the contract. Okay? It's subject matter, the status of the parties, what courts can structurally do well. This is not surprising when we're talking about the social practice of contract. Now, again, some will bemoan its uncertainty, but I repeat again, if you don't like something, you say the sky will fall down, this is too uncertain, but if you like it, you say it's so flexible, right? The flexibility is actually one of the common law's greatest strengths. Finally, all of this, I believe, resonates with Sir Ivor Richardson's conviction that the courts are the people's courts, that the common law should reflect the kind of society that we are and meet its needs. He said that legal principles need to be continually reassessed to ensure that courts are not too far behind or too far ahead of society in their thinking. In doing so, Sir Ivor recognised that judges must probe and test the economic, social, and political questions being thrown up by the law. They can't avoid making value judgments. Judges have to have sufficient nous, he said, sufficient awareness of the nature and complexity of society and sensitivity to their own limitations and influence. And finally, Sir Ivor emphasised the importance of giving well-reasoned justifications, particularly when decisions develop the law. And to all of that, the polycentrist would say amen. Thank you very much.
I'm not entirely sure that I need the microphone, so I'm going to put it down. Tēnā koutou katoa. It's a very poignant fact that we celebrated the life and buried one dean of this law school this week, and we celebrate the life of another dean tonight. Although Ken Keith and Ivor Richardson practiced and professed in different areas, one more focused on public law and the other rather more on private law, there were very powerful overlaps in the work that they undertook. Both rose to the highest judicial office their fields could offer. Both came from humble backgrounds, and in all their work that fact was never forgotten. One boy from 1940s Howick, the other an orphan boy from a farm in 1940s Methven. We've been privileged tonight to hear a rich, fascinating and entertaining lecture from a very powerful mind. And we may be proud too that Mindy Chen-Wishart, also with a humble background, a girl from a state house in Christchurch in the 1970s, rose to be Dean of the Oxford Law School. There's something really richly rewarding about a lecture that reminds us that contract law is not just commercial law, but something that touches everyone all the time. Picking up a point that Mindy made, it struck me that in the short hour between waking in the morning and shutting the front door to go to work, we may each have half a dozen contractual interactions. Switching on the light, turning on the shower, boiling the kettle and firing up the toaster, to say nothing of the goods we consume, the shampoo and the toast that we've already paid for. Just about every amenity in life depends upon a contractual underpinning. If I may make a comment on the nature of common law reasoning, it is that anyone interested in precision engineering should not become a common lawyer. Our work is not exactly scientific, and it's only loosely mathematical. What we do is not so very different from what an art historian, a geographer, an economist, or an applied mathematician does. The job of a common lawyer, and at their apex, the judges, is to find coherence in what others see as an utterly unapproachable mess. For myself, at least, I find a great deal of comfort in the connection between law and history as helping to chart a path forward. Mindy sees arrows in legal reasoning, I see shuttlecocks. The common law is a modern historian's paradise, although our sphere of interest tends to be only the last 200 years. The 18th century is another country, unless, of course, you're my old friend Peter Watts. The case method is essentially historical. It drives us to relative certainties based on a combination of obedience and experience. Obedience, the doctrine of precedent, can be a mixed blessing. It offers some degree of predictability, but as Dame Sean Elias once wisely said, apex courts may not be the best place for new experiments. Experience, on the other hand, is about finding an individual case's place in the broader sweep of history. We look at other cases not just because we are bound by some of them, but because the common law tells us that the relationship between each case in the same subject area ought to be explicable and ought to be justifiable. When we as private lawyers look at precedents, we do much the same thing that public lawyers do when they make submissions to us about criminal sentencing. The process is essentially the same. It's all about the relativities. Now, I have some thanks and an announcement to make. The first thanks I want to express is to our primary sponsor of this event, Minter Ellison Rudd Watts. Ivor, as Dar said, was a partner in Watts and Patterson, one of Minter's predecessor firms between 1973 and 1977. And Minter's sponsorship of this lecture, Hannah and your team, thank you for being here, celebrates that connection and the very important role that Ivor played in the profession, as well as the Academy and the Judiciary. Secondly, I want to thank the University for their co-sponsorship of this event, particularly the Dean of Law, Jeff McClay, and Victoria Beckett and the events team. Thirdly, I want to thank the other members of the organising committee, Justice Matthew Palmer, Professor Graham Austin, and Dar Lin of the Law Faculty. And I have a fourth thank you to make, and its recipient is obvious, but I'm going to postpone it for a moment to make the announcement I foreshadowed. The Ivor Richardson Lecture is given by a New Zealander who has achieved high distinction in private law. They are sometimes expatriate, sometimes still here. The previous lecturers have been Sarah Grimmer of Singapore and London, and Professor David McLaughlin of Lower Hutt. You see, that was the thing about David. He was obsessed with the Socratic method. And he'd answer his question, he'd ask another one. Anyway, I know he's very proud of Lower Hutt, just as I am of Wainemata. Now, 2028 marks the judicial retirement of one of our most celebrated private lawyers, Christine French. There, I was looking for a red jacket. Christine French, President of the Court of Appeal, and I'm absolutely delighted to say that Christine is the Ivor Richardson Lecturer in 2028. Now that you've got your clapping practice in, let's prepare again to thank our 2026 Ivor Richardson Lecturer, Mindy Chen-Wishart, who gave us a rich, thoughtful, clever, and as I say, entertaining lecture on the universal purpose and structure and values of contract law and how it touches humanity. If I may say so, Ivor would have loved it.